where we're going to be focusing on mental disorder and law, which is probably the most traditional arena in which law and psychology have interacted, particularly in the criminal domain. And as you will know, yesterday we focused on a somewhat less prominent interaction of law and psychology by looking at psychological injuries in civil cases, and particularly, specifically in some workplace discrimination cases, such as sexual harassment. We didn't quite finish with all of the presentations that some of you had prepared, and I think we have 3 more people today. And so what we're going to do is just start out with the conclusion to yesterday's session by filling in those gaps with the additional presentations from members of the class. And I think that those are going to be focusing on, I think there's one that involves a law and psychology student together. And then there are 2 others. And so if those, perhaps the next speaker who came up at the end of yesterday and with whom we did not get a chance to really go ahead because of the time, if we can take it from there, that would be helpful. Thank you. Do you need to move the microphone down a little bit, perhaps? Can you hear well?
Is this fine?
That's good. Is it working?
Am I audible?
Yeah.
So technically, psychological injuries are nothing but the trauma you go through or the PTSD symptoms what we have. So in India, most of them, as told earlier, they won't come out to tell that they're either going through an harassment in office or they don't come open and see that having some trauma. And even in India, we don't have a particular case or law which focuses on these scenarios. The only law which focuses on harassment of women, really which focuses. So the only way to prevent such injuries is to go through therapy classes or bring it out or just recognize the symptoms and do. As earlier in 2016, there's a case of in Uttarakhand, that is Praveen Pradhan versus State of Uttarakhand, which states about the suicidal tendency a person has when they go through such stresses. So they've created an association so that they can just focus on how to give medical aid for such people. Thank you.
Thank you. So that was an illustration of a case example out of your community and your context where some action followed after an individual was found to be suffering from some form of psychological trauma or some of the sequelae of an event. And as I understood it, then there was a whole association created to help provide interventions in the form of therapy for those individuals. So very proactive. All right, thank you. All right, and the next presenters.
There's no specific case that I want to cite here. I was actually confused initially when I saw the list of topics. We have something around procedures affecting claims for psychological injury. So there's nothing specifically on psychological injury, but we do have procedures around mental health. So now if you look at the Mental Health Act of 2015, we have a section which basically says once proof is given in court that person has suffering from a mental illness, and that is contested by the other party, and the court is obligated to send this to a board, and the board is defined in the Act, which consists basically of a district judge, two psychiatrists, and there's basically 5 people in the board. The problem, of course, is that it's not directly linked to psychological injury. That is more in the context of a mental illness, something that we talked today. I'm sorry.
The tort cases.
It could cover tort cases. So maybe you can look at the language of the section. It is very broad and covers all kinds of cases. I'll just read the section out to you.
So it would apply to even workplace cases?
Absolutely. So I'll just read the section out. It says, if during any judicial process, before any competent court, proof of mental illness is produced. I don't know what that means, proof of mental illness. I don't know how I would produce that. But it says, if proof of mental illness is produced and is challenged by the other party, the court shall refer the same for further scrutiny to the concerned board, and the board shall, after the examination of the person, alleged to have a mental illness either by itself or through a committee of experts, submit its opinion to the court. It doesn't say the opinion is binding, and it does answer one of your questions here, that the person will have to submit to the board, so the person will have to be examined, and that seems to be almost involuntary here. Of course, this is very new law, so we don't have precedent around how this will play out in practice. We've had some discussions about how this might play out. So one view is, when you say proof, it only means a prima facie kind of view. So if, for example, an accused is brought before a judge for the first time, and the judge is of the opinion, just by looking at him, that he suffers from some mental illness, or the lawyer claims that, or the defense lawyer claims that he suffers from a mental illness, then, and if the prosecution contests that, then it will automatically go to a board. But that view is not strongly supported by a plain reading of the section, because it seems to suggest proof, which would imply a higher standard rather than a prima facie view. I don't have much experience in tort cases. The experience of the procedures to prove mental illness, I do have some experience from death penalty cases, where if you look at where death row prisoners bring out claims of mental illness prior to execution as a defense against execution, the procedure used by courts to reach a finding of whether there is mental illness or not is very similar to that prescribed by this Act, which is they invariably send it out to a board, a court-appointed body or a government hospital. So in Delhi it will usually be IBAS, or there will be the hospital in Shahadra. There will be doctors who are resident doctors there will be asked to conduct an examination. They will be given complete access to the prisoner, and the report will be submitted. That is if, of course, a court case is brought. The other situation in which this can arise is if the prisoner is observed to have some mental illness by the superintendent or by the medical officer in prison. Then, under the provisions of the prison manual, there will be a medical evaluation, and if he's found to have some mental illness, treatment may be given. In several cases, for example, Sundar Singh, if you guys will be familiar with Shatrughan Chauhan versus Union of India, there were two prisoners in that case who were declared to be suffering from mental illness, and for that reason their death sentences were commuted to life imprisonment. So in the case of Sundar Singh there, he was diagnosed to have schizophrenia, and this diagnosis came from observations of the superintendent. So if you look at provisions of the prison manuals, they basically rely on visible symptoms which will be picked up by either the prison medical officer or the superintendent. But again, that is, I think, more directly relevant to today's discussion rather than psychiatric activities. In terms of an example, I think Nanda mentioned yesterday the case of KP's Guild. I think that is a fairly important example. The lady in question filed an FIR and a complaint to the magistrate. The High Court quashed that complaint and the FIR, against which an appeal was filed at the Supreme Court, and the Supreme Court directed the registration of the FIR. It was only then that the case actually went to trial, and then the trial court found found Mr. Gill guilty, and a sentence of about 3 years, 3 months imprisonment was given. Subsequently, as she mentioned, the Supreme Court set aside that imprisonment, and there was no imprisonment ultimately given, and said that he would be kept under probation, etc., and a fine was imposed eventually. So there was no imprisonment that came about. Yeah, I think that should be enough from me.
All right, well, thank you for those great examples and very edifying, so I want to thank Professor Stu. All right, that's just a brief follow-up before the next presentation. I just want to explain a little bit what on earth I added there about US Rule 35, because you were indicating that the way your new law is structured requires this referral to the committee when there is a mental state in controversy, or mental illness or injury in controversy. And that's when Rule 35 in the US Federal Civil Rules of Procedure kicks in. And it will be interesting to see how this plays out in your jurisdiction, because there's been enormous controversy about Rule 35. So if somebody claims compensation for psychological injuries, then they have, doesn't matter what the other side thinks, then they have already put their mental state in controversy in US pleading terms. And that means that they then have to be subjected voluntarily to go forward with a case to an independent medical examination or an examination by opposing experts hired by opposing counsel. And the problem has been putting the brakes on the parameters of that kind of examination. And so you might have, a plaintiff, who's 50 years old, who's claiming an injury about something that happened to them in the last 6 months, and then the case gets subjected to Rule 35, and every single doctor's visit, every single gynecological visit, every single discussion that that individual has ever had with anyone about their mental state becomes a free-for-all, and the courts have had to try to establish some kinds of limits on that, because it was regarded as very punitive for complainants to have to undergo that kind of exposure when some of those records might be years old or might have very little relevance at all to the issues at hand. And so there have been some efforts to provide, particularly in cases where sexual assault has been an issue, at least what are called some shield laws to try to protect the privacy of a complainant who has a legitimate claim for psychological injury and shouldn't necessarily be exposed to have all other aspects of their private medical records, uncovered for all and sundry in the court. So there can be some real downsides to these referrals and a full exploration of things that may or may not be tightly relevant to the issues. The reason the relevance is difficult to constrain is that in order to provide a defense to claims, the defense psychologist or psychiatrist will be looking for other kinds of alternate hypotheses about the causes of an injury, so that if they can find that somebody had a pre-existing fragility psychologically, then that might lead to alternate causes for current symptomatology, as well as the claimed workplace discrimination, for example. So it can be relevant to look at that. So that makes it difficult to manage. A number of other things that I think will be interesting for you to consider is really who gets on the boards that make these decisions. Who appoints the psychologists or psychiatrists to those boards, and what sort of orientation do they have to mental injury or mental disorder and so forth. And perhaps the relevance of that will be more explicit once we work through today's materials on some of the medical models that are associated with that. I think, I think that can make a difference sometimes to the outcomes or people's willingness to invoke those procedures. The interest that I had in the way your legislation is framed in terms of a proof, I think your discussion of that is really informative and interesting, ranging from the observations by jail wardens or superintendents and so forth to judges in court, is interesting in light of what I really provided for you to read yesterday, where the thrust of some of those models for analysis that I developed with the report was really trying to provide more systematic and objective ways to examine proof that's relevant at all different stages. So clearly finding the proof of those issues that might be your threshold issue, I anticipate is going to become quite a broadened area, perhaps of litigation under those regulations in the future. Right. So thank you. Let's go through, I think, our last presentation. So please come up.
So I'm going to talk about corporate liabilities for psychological injuries. I think as yesterday we've discussed and as everyone else has said that we have certain laws for certain guidelines of protection of women employees against sexual harassment, but I think we need more non-gender based laws to protect both men and women against all types of harassments or bullying. So I think we don't have any concrete law for the protection of the honor and dignity of the employees in the workplace. Any law which basically states that, any law which basically talks about the work environment as such. So why this law is important is because research has shown that the work environment plays a major role in the work performance of the employees and in the basic career satisfaction of the employees. So I think we need to have this law, and harassment or bullying also affects the confidence, the mental health, the physical health, and the basic work performance of the people in general. So, and one thing is really interesting here is that most of the time these things are not reported, mainly because people don't understand. People sometimes think that, maybe this is my supervisor's way of just disciplining me. Maybe he's not bullying me. So there's no proper understanding of what is bullying and what is disciplining the employee. So the first step that we could have is a proper definition of what is discipline and what is bullying or what is harassment for both men and women. And I guess there should also be a proper and regular training for all the senior officers and their subordinates regarding leadership training, executive coaching for the senior officers, and just the regular psychosocial training or how to deal with these matters. There should be regular training in the corporate sectors itself. And as I mentioned, the laws need to be they are very vague, so they need to be more specific. If we have a more, step-by-step process or a proper...
I think somewhere what we need to do, Sakshi, is you have to just pinpoint on what is present, not on what we should. Because that's something that we will reach to later. If we get into that speculative mode now, then she's wanting us to provide context. So you have to more say that this is not present. And we have to think about what we have. So if there is something, if you know of a corporation or you know of a place wherein some kind of a package has been created, whatever way, focus attention on that. Otherwise, we just kite flying.
Okay. I'm not aware of any.
So then that is the authoritative information we have to give. Okay. So we should just say we don't have it, because it will set up a right context for change. And she'll get confused between what we have and what we want.
Okay. Yeah, so this is what I'm saying, that these are the things I think we should have, not that we have. We have certain laws on sexual harassment for women in workplaces.
Yeah, which is what Akshay spoke about.
Yeah, exactly. I guess that's it. Thank you.
Okay. All right, thank you. Well, I think you're right. You've given us some prevention mechanisms for the future that are interesting, and those are huge areas of psychosocial research in terms of bullying and so forth that we haven't had much time to talk about in this session, and some of the measures of workplace culture. All right, so thanks again to all of those of you who have contributed to expand our thinking about what the current context is. I do want to ask others in the class who didn't have a chance maybe to comment or speak on that, if there are any other contextual issues related to that list that you're aware of, that are current circumstances that you would like to speak about. Okay. No, not at this time. All right. Well, then we're going to shift gears and move on to the material related to